All right, committee, we'll come to order now. Everyone, welcome to Senate Utilities Committee. And for those of you watching online, you can go to kansaslegislature.org to find the documents that we're talking about. You look across the top tab for committees, and then look for the Senate committees. Navigate to the second page of the list of committees and look for the Senate Utilities. And then on that final page, look for committee testimony. You click on that, it'll give you a little box. Sometimes you have to click 2 or 3 times. The box will highlight on the date. You click there and the PDFs will show up. So today we're going to continue our hearing on Senate Bill 349. As you recall, yesterday for proponents, we gave proponents 20 minutes. We gave the 10 minutes for neutral testimony and 20 for opponents, of which about 6 or 7 has already been utilized. So today we'll use the rest of that time for our 2 opponents in person. And we're going to start with Whitney Dameron from the Empire District Electric Company. And Whitney, welcome to the committee. Is your mic on? It doesn't sound like it is.
They would.
There we go. That's
okay.
better.
I won't start.
Reintroduce yourself again. Well, yeah, we'll restart the timer.
Whitney Dameron, the Empire District Electric Company, doing business as Liberty. Our footprint is in the southeast corner of the state of Kansas. Liberty is an investor-owned electric utility, second largest in the state of Kansas, of which there are 2. The proponents of the bill yesterday suggested they would amend their bill or seek to amend it to remove essentially its application to Liberty based upon size. Our customer base in southeast Kansas is about 10,000, give or take. That said, the bill before you is of concern to us. I have some opinions we'd like to express. Number one, I think it was suggested yesterday by Mr. Caseley with Evergy that this legislation would highly unlikely withstand legislative scrutiny or legal scrutiny. Utilities, by their nature, have an obligation to serve. There also is an obligation that they get paid for the service that they provide. The way this legislation is written, I guess you can artfully try to get around that by suggesting that, no, you'll get paid, but you just have to toll your costs incurred that are over that 1% allowed rate, as well as the carrying charges. And a decade from now, half a generation away, we'll just drop a rate bomb on those people left in the state of Kansas to pick up the tab for that. But between now and then, those people in Kansas would be the beneficiary of not having to pay for those costs that are and services that are provided to them. We understand that the proponents of the bill are very serious about their concerns with increased electric costs. Utilities are as well. We do what we can to try to keep the costs down. That argument, that debate is held at the Corporation Commission. They have capable staff that weigh in on rate cases. Citizens Utility Ratepayer Board is obviously a part of that, and interveners, many of which who were represented in this room yesterday. That's where the discussions on allowable rates take place. The state legislature does determine policy, certainly on items that can be recoverable and things that utilities may or may not do. We've seen that with legislation on renewables and transmission and other areas like that. Quite frankly, we don't, with all due respect to the proponents, we don't see this as a serious bill in that we don't think it could ever become law and be enforced. That said, we do take their concerns seriously. So I don't mean to diminish that by any stretch. With that, Mr. Chairman, I think if there's a need or an opportunity to have a discussion about rates and what goes into rates, that's something that's entirely appropriate for this committee and others as well, and we'd be glad to be a part of that. Thank you, Mr. Chairman.
Did you need to get to another committee at this point?
Another committee. I told them give me about 10 or 15 minutes, so I'm going to hang around for just a little bit.
Sheila, if you can stop the clock momentarily. Committee, do you have any questions for Mr. Dameron before he has to bug out? Seeing none, thank you for your testimony, and I appreciate it very much. Up next, we have Justin Grady from the the Chief of Revenue Requirements from the Kansas Corporation Commission. Justin?
Good afternoon, Senator Thompson, members of the committee. My name is Justin Grady. I'm Chief of Revenue Requirements, Cost of Service, and Finance at the KCC. Appreciate the opportunity to appear before you this afternoon to discuss our concerns with Senate Bill 349. You do have my written testimony, and I would encourage you to review that written testimony. It's 3 or 4 pages long, and it goes into a little more detail than I'll cover today regarding some of our chief concerns with the bill. Our concerns are primarily within 2 sort of broad categories. We have real concerns about the legality, the lawfulness of the provisions, some of the provisions, and I'll hit on why that is today. But also, our concerns are that if the bill were to get through the inevitable litigation and appeals process, then we have real concerns about the implementation of the bill and what some of the unintended consequences could be in terms of higher rate case costs, more drawn out, longer rate cases, and then ultimately diminished access to capital and higher cost of capital for electric utilities in the state. Before I get into too much more of the meat of the testimony, I wanted to mention that because our more significant concerns about the bill are legal in nature, I do have the Chief of Litigation Counsel here in the audience with us today, Terry Pemberton. She's the KCC's Chief Litigation Counsel. And so if there are any questions of a legal nature regarding our testimony, she helped me provide that testimony and put that together, and she's certainly available as well. So the premise of our concerns really specifically pertains to the inconsistency. If this bill were to become law, the inconsistency with this bill and 66101B. And 66101B requires the commission to set just and reasonable rates in order for the utility to be able to provide efficient and sufficient service. And those are somewhat ambiguous terms. But those terms have been interpreted by the courts, and the Kansas Supreme Court in particular has mandated that a just and reasonable rate is a rate that was set after the consideration and balancing of the following interests: current ratepayers versus future ratepayers, ratepayers versus investors of the utility, and then the public interest generally. And we have concerns that with regard to that, actually both of those first 2 components, the balancing of interest between investors and ratepayers, and then balancing of interest between current and future ratepayers. And so with regard to the intergenerational inequity issues, or current versus future ratepayers, there was some discussion yesterday about inflation and what inflation levels have been and what they've been running recently. Up till, about the last 13 months, inflation in this country was around 2%, a little less, for about 10 years. But more recently, of course, inflation has run a lot hotter than that, more like 7 or 7.5% annualized rate. But if we presume that inflation were to return to normal relatively quickly and run around that 2% level, then essentially what this bill would be asking is for regulated electric utilities to manage the inputs into their business costs to a level that was about half of the rate of inflation for a 10-year period of time. And electric utilities in Kansas have, over the last 5 or 6 years, done a good job of managing their costs within that structure. But what I would say is we caution that it's going to be very difficult for them to repeat that level of performance and to keep that for a period of 10 years. So what our concern is that let's just say the utilities manage their costs around the level of inflation over the next 10 years, and that's the cost structure that is required to provide efficient and sufficient service. Then, as you've heard from some of the other opponents, what would happen is those costs would be deferred into a regulatory asset with carrying charges, and then for a period of 10 years, and then the next generation of ratepayers would pay those costs. That's not an insignificant impact You think about, and I put this example in my testimony, but if you assume a weighted average cost of capital of something like 7.2%, which is pretty close actually, and just the rule of 72 that everybody from corporate finance understands is, 7.2% money doubles in 10 years. So if we're talking about a 10-year period of deferral, then you really need to think about, that means that whatever costs that are necessary to provide safe and reliable service that we don't bill today's ratepayers are going to be accumulated and billed to the next generation of ratepayers at double whatever benefit people get today. So I think that's really important to consider and think about. I guess while I'm on that, one other quick thing, there was an example used yesterday by Mr. Snyder. He said, this really isn't that different. We defer costs and spread costs out in rate making all the time. But while at a high level that's an accurate statement, we do use deferred assets and regulatory liabilities to spread costs out. But as an example, Winter Storm Uri, those costs were incurred, audited, approved, and will begin to be recovered from customers within a 1 or 2 year period of time. And some of those costs may be recovered over 5 or 7 or 10 years, but that's holistically different than waiting 10 years, allowing this generation and this group of customers to benefit for a 10-year period of time, and then 10 years later bill another generation of customers. That's holistically different than anything that, this is my 20th year regulating utilities, being at the KCC. I'm not aware of anything like this ever having been done at the KCC. And I think some of the opponents yesterday mentioned, nationally that there isn't anything like this that's been done. How are we doing on time? Okay, great, thank you. So with regard to I think that pretty well covers the intergenerational inequity concerns that we have. We think that pretty squarely runs in opposition of what the Kansas Supreme Court has said is the goal of the commission and rate-making proceedings, and we're concerned about that. The other aspect is from a just compensation perspective. In this country, if you're a private corporation, you're a private entity using private investor capital, or a publicly traded entity providing a public service to the state or to the people of Kansas, the Fifth Amendment to the United States Constitution guarantees that you have an ability, or an opportunity at least, to earn your costs back and have an opportunity to earn a rate of return, and we call that just compensation clause. Well, we're not aware of anywhere where a private corporation providing a public service has been required to wait 10 years to receive that just compensation. And we really question whether or not the courts would determine that was just compensation. And I think that's that takings argument, or that confiscatory legal argument that you heard yesterday. And so that covers our legal concerns. We went into more detail in my testimony, my written testimony. But on the implementation side, if this were to survive appeal, our concern mainly is twofold. One, there's an exemption in the bill that would allow for rate increases over 1% in the event that the commission determined it was necessary to protect reliability or to prevent negative credit degradation. And what I would submit is that, and you heard this yesterday from Curb and some of the other interveners that are involved in KCC rate-making proceedings should be able to confirm this as well, is that if a cost isn't in some form or fashion related to preserving reliability or preventing financial degradation, then those costs are eliminated from the rate-making proceeding, and they're not built into Kansas electric rates. And so, it's the ambiguity of those terms, and when we're administering the statute, all of the fighting and the delay, the complexity of the rate cases and the increased rate case costs is what our real concern is there. And then this was discussed yesterday, so I won't go into it too much, but I have a background an educational background in corporate finance and investment management. And, financial theory suggests that if if subjected to the uncertainty and the possibility that you may have to wait 10 years to receive a just return and a reasonable return on your investment, we would submit it's highly likely that the result of this legislation would be increased capital costs and decreased availability of capital for investment utilities in the state. And, I actually think that the proponents of this legislation are underestimating that risk. And unfortunately, I think that the very real possibility is that the unintended consequence of this bill could actually end up being higher electric rates in the end. So that, I think that pretty well summarizes the written testimony. I appreciate the opportunity to appear before you this afternoon, and certainly look forward to any questions that the committee might have.
Okay, thank you, Justin. Committee, any questions? Senator Olson.
Justin, and you just touched on a point that I'd been thinking about, that this is going to cause rates to go up because the cost of capital is going to go up because they're being able to get it back is going to take longer. And do you think these rate agencies, you think they're looking right now and listening, got someone listening in on to what we're doing? And do you think they've got concerns, and if we keep going down this road, do you think cost of capital is going to start going up? I mean, do you have concerns about that?
Well, Senator, that's a good question. I don't know if anybody from S&P or Moody's would be, tuning in and listening to this particular hearing. I would say a proposal like this on its own, I haven't seen any evidence that this is, made the national news or that there's any significant concern about this yet. But I do believe that if a bill like this were to become law, I do believe that there would be impacts. It certainly would catch the attention of the rating agencies. People that provide debt capital to utility companies are nervous people, and they want that utility to be able to recover all of its costs and in a timely fashion. And 10 years is not an insignificant period of time. So it's a concern of ours, and it was something we focused pretty heavily on in our written testimony.
But I mean, if they see that we're continuing down a path to have a lot of legislation like that, do you think then that would draw concern?
I would say that it is certainly not outside of the realm of possibility that the further this legislation advances, written in the fashion that it is, there certainly could be those impacts. I don't know about any other bills. This is the only one I'm discussing.
Senator Hawk.
Thank you, Mr. Chairman. Just a question on, you mentioned rate cases. Refresh my memory, how often does a major company do a rate case with a KCC like Evergy? Is it every 3 years or 5?
Oh, we could, from memory, I can go back to around 2002. There are major full rate cases around every 3 years. There was 02, 05, 08, 12, 15, 18. Abbreviated cases sometimes in between those full rate cases, depending on what's going on. There were abbreviated rate cases for wind farms when Evergy completed the Emporia natural gas-fired generating unit, when we were reviewing the retrofits, environmental retrofits on Lacine. There were abbreviated rate cases in between full rate cases. But more recently, Evergy's under a 5-year rate moratorium, right, for both Westar, the old Westar and KCPL systems. So their next rate case isn't going to be filed until early 2023, with rates in effect late 2023 or early 2024. Empire, on the other hand, they have an abbreviated case in right now. We did a full rate case for them in 2019. And honestly, I think the last full rate case for Empire would have been, I think it was a 12 or an 11 case. They don't file cases all that often.
So speculation question, I probably ought to ask the utilities, but you mentioned in terms of, protecting reliability where that doesn't come under this 1% cap. Is it your opinion that they would probably file rate cases, certainly the abbreviated ones, more frequently, just to make sure that they could keep reliability up if they were capped on their ability to do certain things?
Yeah, we talked about that as a possibility. The reason that didn't make it in my written testimony is because I guess my interpretation of the bill is that, if you don't file a rate case every year, but you file one every 5 years, then that fifth rate case can be a 5% increase. And so I guess I didn't view that as a tangible risk that they would feel like they would have to file every year to stay under that 1% threshold. So I guess that's my response.
Thank you. Appreciate that information. Thank you, Mr. Chair.
Senator Fagg, do you have one?
Thank you, Mr. Chairman. Mr. Grady, this is kind of looking forward here. I know the cost of electricity, when we look at our state compared to other states, has been on the high side. And from your standpoint, as you look at things, do you look at other states too, just to see kind of what's out there? And where my question's going is trying to look 5 years down the road, and when we look at this, have we seen CapEx expenditures? We've seen securitization we've got in the toolbox. How is our price of electricity going to be compared to other states?
Well, that's the $10,000 question, but it's a really good one, Senator. So we are as aware as we can be about what's going on in other states. Every time an Oklahoma or Texas or an Arkansas utility files a rate case, I get a little reminder through SNL, S&P Global Financial. It's tough. So what I think is reasonable, I do think it's reasonable for Evergy to be held to a standard of maintaining its rate increases at or below the level of inflation. I think that's reasonable because regional rate competitiveness is very important. It's important to the commission. Evergy says it's important to them, and they talk about it every time they have an investor call or otherwise. I know it's important to this committee. But regional rate competitiveness is a little bit difficult to target because you're not in control of what any of the other states are doing, right? So in my written testimony, I have what rates have done in the last 6 years in Kansas, right? And I didn't know that this bill was going to be revised to relate specifically to Evergy, so Empire's rates are in there too. But on an all-in basis, including everything else that you heard about yesterday, transmission delivery charge, fuel costs, everything else, electric utilities in Kansas have maintained have increased their rates less than 1% over the last 6 years on average, right? And the numbers are in my written testimony, and that's not an accident, that's not a coincidence. It's because we've been heavily focused on this, and it's been a priority since before Mr. Snyder started discussing it before this committee. It's been an issue of the commission's. We've been heavily focused on it up to before when we denied the first merger request between KCPL and Westar and said that's not beneficial enough for customers. So try again and have all that benefit go back to customers. So it's a tough question. I don't know. I hope I've given it, did it some justice. When we reviewed Evergy's sustainability transformation plan, we compared Evergy's capital expenditures per capita to every other utility and 23 utilities in the Midwest. And what we found is that they are growing, they are doing investment. They have, they've been upfront about that. We were upfront about that. And there's a lot of aging infrastructure that will need to be replaced, but their investment relative to their peers is not median. It's bottom quartile or low. It's relative to their peers. They're not investing a lot, And so when you have that, plus the efficiency initiatives that they've pursued with becoming more efficient on their O&M, I mean, we're optimistic that we're going to continue to get better and improve our regional rate competitiveness. It's just hard to pinpoint exactly what it'll look like in 5 years. But in the last 6 years, I think they've done a pretty good job.
Any other, Senator Francisco?
Thank you, Mr. Chair. We also got some written testimony on this bill from the Climate and Energy Project, and they're indicating that the public filing for the Evergy docket talks about a net impact of a suite of energy efficiency programs that might be just a bit more than 1%. So that would eat up any opportunity for energy efficiency projects.
Yeah, that's a good point. I mean, we're right in the middle of reviewing that energy efficiency suite, so so it'd probably be inappropriate for me to speculate what the outcome of that will be. But if the program was approved in its entirety with all of the incentives and everything else that's been requested, then I think that's the number that I recall, is that the rate impact or the bill impact is projected to be something around 1.5% over the next 2 or 3 years, and then they project that bills would come down as people take advantage of those efficiency measures and whatnot. But your point is well taken, and that's just one initiative that they are attempting to pursue, and they would say we're pursuing that because the legislature passed KIA, and one of the top lines of KIA is it is the policy of the state of Kansas to do cost-effective energy efficiency. So, I mean, that's a good point.
Thank you.
I've got a few for you, Jason. Or Justin, I'm sorry about that. First of all, I can't remember exact number, what's the authorized return on equity for the IOUs? Is it 9%, 9.5%?
So Evergy's authorized return on equity, I believe, is 9.3%. If it's not, then it's 9.35, 9.3 or 9.35. And I think that Empire's was equivalent to that, if not 9.2.
Would that give them any cushion with regard to, I mean, say we were to lower that authorized return on equity, what impact would that have for them to, obviously I'm searching for solutions here, as is the carrier of this bill, to try to keep things under control. What impact would that have?
Well, certainly, Senator, that's accurate. So they have an authorized return. They have an opportunity to earn that return. There is a level of net income that's built into their rates. And so, but the bill also allows them to defer any increases over and above that, what it would take to provide electricity over 1%. So, I mean, that operating cushion allows them, year to year to, they don't earn over that authorized return, right? In Kansas, if they earn over that authorized return, that gets shared back with customers because of this earnings sharing plan that's in place. But that would allow a cushion for unanticipated changes in the business climate, or COVID, or Winter Storm Uri, for instance. Customers aren't paying for that still, right? It's just being held out there by Evergy. So, but I think the real concern from a financial markets, capital markets perspective would just be the unusual nature of this. This isn't, honestly, I'm not aware of anything like this anywhere in the country. The examples that were given yesterday are examples of voluntary mechanisms, right? Where a utility can voluntarily put itself into a plan that says, I get to increase my rates, this frequently, but only by 1%. But it's the uncertainty associated with what is going to happen with inflation. What are our costs going to do? So anyway, that's what our concern is.
Of course, inflation does affect the consumer as well. So, I mean, that's
It does.
You got to worry about that. And I guess just I'll cut right to the bottom line and sort of dovetails with what Senator Fagg said, and that is, if you could wave a magic wand and give us a solution for this, or work with the carrier of the bill, what would your suggestion be?
If I could wave a magic wand and propose changes in law that would absolutely ensure that Evergy's rates would be regionally competitive for the next 5 years, outside of all of the business forces that company faces that are outside of my control and outside of their control, then we would have already proposed that solution. It's a difficult question. If you're asking what sort of changes would be necessary to this bill to make it palatable and so that it would potentially be legal, we would be guessing. That'd be speculation. What I would say is the 10 years I think would be far too long. I think it'd have to be shortened to something like 3 years. And then I think you're going to be, at that point, people are going to say, what's the purpose of this? We're only absolutely ensuring rate stability for a 3-year period of time, and there's going to be a cost for that. That's, on the back end. I think the problem is that the reason something like this hasn't been proposed, the reason we're not aware of something like this being in law is that there just is this strict legislative and legal framework that exists to set utility rates. And we have to balance the interests between investors and customers, and today's customers and tomorrow's customers. And it's not an easy task. I put that 6 years of rate history in the written testimony because, it's true that, we did a discussion of the regional rate competitiveness of Kansas's electric rates. You can look at that and see that, on an apples-to-apples basis, Evergy's rates are 5 to 7% higher, depending on what class you look at, from a lot of their peers. And so there's still more work to be done. But this has been a top priority for the commissioners and KCC staff for a long time. And, it's inaccurate. Yesterday there was assertions that we haven't done anything, we haven't been part of the solution. We've been integrally involved in this legislative process. We were in the room when the final negotiations were made last year on the securitization bill. We were heavily involved in the legislation that everybody ultimately agreed to and brought before this committee to reduce state income taxes on utilities. So it's just tough. Unfortunately, there are no easy answers. I just wish there were.
Okay. Senator Francisco.
Thank you, Mr. Chair. So if Kansas is able to attract a $4 billion industry that makes use of electricity, what effect will that have on rates?
So that should have a positive impact on rates, no question about it. A lot of the details, of course, are not public, but if you recall, you go back to when we did our really truly deep dive into what separates Kansas's electric rates from the states around us. A really, really important factor is how many industrial sales you have. And it is a little bit of a chicken and an egg thing, because if you have lower rates, you get more industrial sales. But if you have high rates and you get a bunch of industrial sales, then your rates go down as well. And so to a certain extent, a lot of the business of producing electricity is fixed. And the more denominators you have, the more usage you have in that denominator, the lower the rate's going to be. To a certain extent, it's just math like that. So it can't hurt. I'll say that.
Thank you, Mr. Chair. And I, of course, would appreciate a hearing on Senate Bill 480.
Okay. Any other questions? Seeing none, thank you, Justin.
Thank you, Senator.
With that, I think we're going to close out the hearing on Senate Bill 349. Committee, we will we'll see where we go with this in coming days. I want to take a few minutes and indulge the committee committee's patience, I want to make a comment on Senate Bill 353, which is the turbine health and safety bill. We've got turnaround coming in just a couple days, only a couple more days left to do the work in the committee prior to turnaround. We spent a good deal of time examining the health and safety risks of industrial wind turbines for a pretty good reason. There's a lot to know. We've heard from cardiologists, we've heard from acoustical engineers, we've heard from a lot of rural landowners, some who are in the room today, some who are watching intently online and have been begging for the state to do something to protect them and their families and their properties. If anyone's under the illusion that this issue cropped up just in the last year when we first heard Senate Bill 279, let me assure you it's been festering for quite some time. In fact, there are now 3,979 turbines in the state of Kansas with projects in the pipeline for all 105 counties. So this problem's not going away. It's only going to get worse. And as more of our constituents are directly impacted in the communities, they're going to be coming to us for help. Now, unlike nuclear plants, which is very clean electricity, and other electrical generating sources that are enclosed and the threats are contained, those 38-ton blade assemblies with rotational velocity of about 200 miles per hour are out in the open and exposes anybody living or working nearby to the dangers that they present. Plus, over the last 20 years, the turbines have grown in height from about 200 feet to the new ones, which are 650 feet tall, which is twice the size of this building. And as they get a lot bigger, the health threat becomes more severe. Ice throw can be thrown farther than the 3,200 feet that we know it can now. Shadow flicker will be worse. Bigger blades can disintegrate during high wind events, and collapsing turbines fall to the ground. That happens here in Kansas. We've seen it. And a turbine fire at 600 feet can't be extinguished by the local fire department. It has to burn out. So here in Kansas, we have a statutory duty to protect Kansans from these documented health risks through KSA 74-7284. And that declares in that statute that the purpose of state government is to keep secure the constitutional rights of Kansas citizens to protect their health, safety, and welfare. Now, we've heard testimony on Senate Bill 353 from citizens who are rightly declaring their constitutional rights are not secure. You've heard testimony from citizens who believe that we failed to protect their health and safety and welfare. We've heard testimony from multiple qualified experts in the field of health who have presented negative impacts associated with wind turbines. We've heard the opponents state their case. And one thing's abundantly clear: the lack of proper jurisdiction as to setbacks in the planning and build out of industrial wind turbines in very large expanses of property is inadequate regarding non-participant property owners. And that issue is something we've got to deal with. I've been into a lot of small communities around Kansas and even in Missouri, and at all these meetings, hundreds of people showed up at these community meetings to express their concerns about how the turbines are going to be sited and what the impacts would have on their family just because somebody next door decided they wanted to put a turbine on their land. Now, opponents of this bill have stated they won't go into communities where they're not wanted. And yet, Nextera sued Reno County when residents there rejected the conditional use permit. And that forced private citizens and the county to expend hundreds of thousands of dollars defending their decision against the wind companies. That lawsuit is now 3 years old. The same thing's happening in Marion County, and those threats are happening elsewhere throughout the state. Now, these residents who don't want their families exposed to these health risks don't get a choice, and their rights have been completely ignored. Now, committee, you may not be aware, but there are thousands across this state who are paying attention, paying very close attention. In fact, just this morning, I got an email from a person in Canada who's paying attention to what's happening in this state, and they are hopeful that we, at some point, can do something because we could set a standard for the rest of the country. This issue is not going away, and the time to ignore the need to do something is rapidly coming to an end. For From here on out, everything the wind industry does in Kansas is going to be under scrutiny. People are watching and documenting the action, so this committee will have all the information it needs. And unfortunately, it's difficult to communicate in a few weeks to this committee what I've spent years trying to learn about this issue. But unfortunately, that's how the committee process works. Now, if I examined the situation and confirmed with some of the members of the committee, as chairman, I've come to conclude we're not able to advance Senate Bill 353 today. However, rest assured that the shortcomings of the state statutes, the shortcomings of county commissions, and the shortcomings of local governments have been duly noted related to the impacts on the citizens of Kansas. And as the session advances, if and when I can sense that moment has arrived, I will convene a proceeding that will be directed toward working this piece of proposed legislations. Short of that happening, we will be revisiting all of the shortcomings of the statutes. And I know that all of you are from small towns today are hoping this committee would get something done and take the next step today. I know that you're feeling disappointed and discouraged, and we have more work to do, and I have more work to do as a chair, educating the committee so that we have all the information necessary to make the best bill possible. Committee, I thank you for your indulgence. We must help these folks. They're worried, they're frustrated, they're tired, their patience is wearing thin. And going forward, I'm just going to ask for your continued work on this to continue to understand this complex situation. I thank you with that. With that, our work is done today, and I would adjourn. Thank you.